morning. Can everybody hear me? Great. My kids always say they'd rather not, so I have to always ask. So quickly and first, as I start my timer, I want to thank the organizers. This is an extraordinary historical meeting, and I'm honored to be part of it along with my co-author, Francesca Nardi. I would thank you all by name, but I don't want to take up the time. Our topic this afternoon is meeting the evolving challenges for embryo disposition post-Dobbs and examining the critical role of contract law frameworks. I sort of shorten this up to divorcing embryos when I teach this, and I teach it for about 2 weeks, so shortening it to about 9.5 minutes is going to be a challenge. I also just want to mention that in addition to teaching art law at Georgetown Law Center, a Jesuit institution, where they told me I could teach it as long as I didn't do it, I also have had a private practice in the art space for about 30 years, and some of what we've written has been informed by my practice advising patients, providers, clinics, policymakers. So I sort of bring that framework here. So let's just get started here. I want to frame the issues. As everybody's aware, the disposition of unused embryos has plagued this field since the cryopreservation made them possible in the late 80s. We argue that today's fragmented approaches rely variably on too many types of laws, contract, health, family, and constitutional, ultimately detrimental to security for both providers and patients. I want to be clear that informed consent is an absolutely fundamental principle, and health law is critical to informed consent for the medical procedures of IVF and ART, including the right for patients to withdraw, the duty of care that physicians owe to all of their patients. But when it comes to disposition of unused embryos when treatment has concluded, it is ill-fitting and problematic. We think that health law and contract law serve very different purposes, and that a contract framework for disposing of unused embryos offers many advantages and is a preferable framework. In the absence of that, trying to apply informed consent, as we did in the late 80s, to this topic ends up with things like, how long does the duty of care last? As long as embryos are in the freezer, does a physician have a duty to their former patients? In a state that is looking at personhood legislation, are embryos patients indefinitely? Can withdrawal happen forever and ever? So lots of questions that I think are answered much more effectively with a contract lens. And we're not saying that contracts are perfect, but we think they're preferable. So historically, I think most of the people here are familiar with this. Many of you have written about it, but we're not going to spend any time on it this morning. We know that courts have historically adopted one of 3 frameworks and often mixed and matched them, as I call it. Is there a contract when these couples divorce and can't decide on what to do with their embryos? If so, does it apply? If there is not an applicable contract, should we balance the interest of the one who wants to procreate, usually but not always the wife, against the one who wants not to procreate, usually but not always the man? Or should we look to contemporaneous consent? The third being what I call the laughable approach, because if everyone could consent, they wouldn't be spending hundreds of thousands of dollars in court fighting. What we have found in examining these cases in depth, which we do in the article and I do much more in my classes, is that even when there is an applicable agreement, there seems to be a huge reluctance on the part of the high state courts to defer when there is a procreative choice. They are much more comfortable saying, yes, you agreed to discard, you should discard, but when it's, wait, you agreed she could use them, there is a reluctance. We see this in a lot of the cases, starting with the seminal case of Davis versus Davis, and going through, we trace them through the article. The courts use different types of language. We say we don't want to force particularly men to be parents against their will, whether that is genetic or legal. There's some parsing of the definitions there. It has become very difficult to reconcile the Dobbs approach to forcing pregnancy and continued pregnancy on women and honoring men's right not to, quote unquote, become a legal or genetic parent. So what we're seeing, I think, is a dramatic shift in the landscape. There's a new cluster of cases. We hesitate to call it a trend. There have always been lower court cases with sympathy to these patients. But we have seen 4 cases in particular that we focus on in the article, 1 in Pennsylvania, 1 in Maryland, and 2 in New York, that have found agreements to procreate to be binding and enforceable. And one of them, the Pennsylvania court went on to say, sir, genetic parentage does not a legal parent make. What we do with those, we don't know yet. I think we're following them carefully. The Davis decision, I just want to make 2 points very quickly. which is it was the first and seminal case. It relied on a definition of special respect because of the possibility that an embryo would become a person, and it relied on the American Society of Reproductive Medicine's definition in its first ethics committee, on which, as Doug pointed out, Father McCormick was a member of that committee along with Howard Jones as the chair. The court balanced the interests because there was no operable agreement, and in balancing the interests with special respect said the husband could discard the embryos. The decision belonged to the patient, and the decision was discard was acceptable. So what we've seen in the last few years is obviously a dramatic shift in the reproductive landscape in the United States. A lot of you have talked about it already. Many more of you have written about it. We're not going to spend a lot of time, except to say it has become an open season invitation on legislatures and courts to restrict reproductive rights and ART options. Interestingly, I think it is also giving us an opportunity, that's my halfway mark, thank you, to separate reproductive autonomy questions about legal versus genetic parentage. And I think we have seen a small opening where courts and legislatures are starting to say, perhaps you can withdraw your consent to be a parent if the embryo has not yet been transferred, but you cannot necessarily veto a prior agreement. State legislatures have been very, very active in this space. A lot of people are going to talk about it today, so we're not going to spend time on it. There are laws that are impacting explicitly and implicitly IVF options. We have seen proposals for forced embryo donation, sometimes talked about only in the unused, abandoned space, if you will. I think it extends more broadly than that and would be quite impactful on patient choice. We're seeing legislation under what conditions you can have these decisions made or enforced, and we're also seeing ones on legal parentage. Ironically, Arizona and New York have both passed express legislation that says you may withdraw as a legal parent, but not as a genetic parent, and the one who wants to procreate should be allowed to use the embryos. Arizona being a pro-procreation after an oncofertility case, New York being binding agreements under their Child Protective Safety Act. So to me, it's very interesting that from very different perspectives, we have some consensus emerging. So my last slide in my last few minutes is our reflections, recommendations, and challenges for disposition of unused embryos. I want to be clear first on a general level. We are recommending a legally bifurcated framework, separating disposition for unused embryos as contracts, agreements between clinics and patients from informed consent for the medical procedures. We feel it aligns the patient, provider, and offspring interests more closely than other frameworks, and it provides more secure legal outcomes. Both Dean Dar and I have been on the SART Model Forms Committee for over 15 years now. This is the model that SART, the Society of Assisted Reproductive Technology, has proposed. We have created model forms. We have revised them, updated them, and trust me, this is a Goldilocks issue. I have taken flack on every level on this proposal. They are too long, they are too short, they are too cumbersome, they don't cover enough, they're not up to date, they're too far, et cetera, et cetera. They are imperfect, but I do think they reflect a very wise path forward. We recommend that laws allow, as Arizona and New York do, the withdrawal of consent to be a parent. I think it will minimize a number of the conflicts we're seeing in these courts. Clinics, finally, should not require court orders in lieu of agreements. This is something that on the ground I have been very troubled to see in the last few years. I don't know how many else rest have you had, but I am hearing of clinics and large practices who say, you know what, duke it out. Tell us what it comes out to, and when you bring us a court order, we will abide by it. I think that totally misaligns patient and provider interests. I think it disserves their patients. We all know what litigation looks like. It takes years and years, and procreation delayed becomes procreation denied. The person with the most resources and the most stamina is going to win those fights, and usually the women are not going to be able to procreate. So this idea that we're going to step back, I think misaligns patient and clinic interests and should not be something that we encourage. I want to acknowledge before I move on in my last minute to the specific recommendations that I understand we acknowledge that there is no legal framework that will address all these challenges, and especially in states with personhood laws, we are looking at some very significant challenges. On the specifics in closing, we should have documents, agreements that document every opportunity patients are given in a clinic within a jurisdiction that is allowed: divorce, death, legal separation, end of treatment. We should allow a change of mind, but only when the couple, the people who enter into the original agreement, agree to enter into a new one. Updated agreements are fine, but they must be joint. One person should not have veto power, and clinics should be free to follow the agreement on file without liability, unless and until they are presented with a superseding agreement. We recommend legal counsel. There's some very important issues outside of the practice, including parentage. They're also very critical issues, but we don't want to see them required because on the ground, I can tell you it doesn't work. Patients do not want to do it. They are not going to do it, and we're going to end up torpedoing the very efforts we're trying for. Finally, clinics, I think, should be able to follow the agreements to provide and transfer embryos for reproductive use without liability from the other partner. They can withdraw parentage, they cannot withdraw a prior agreement to use. And clinics or storage facilities, if the embryos have been moved, should also be able to follow agreements previously made by the patients to discard embryos without a confirmatory or additional information. That often becomes an invitation to litigation, change of mind, off to the races, and whoever has the most money wins. So in closing, with my last 7 seconds, I want to just say thank you. I think contracts are not perfect, but I do think that they offer a more secure, more clarity, more certainty, and protect reproductive autonomy more fairly than other frameworks that are available. I very much look forward to the discussion. I am incredibly proud of myself for finishing in 10 minutes. Thank you.
All right, panel 2, we're going to stay on track. I love it. My name is Vincent Joralemon. I am the director of the Life Sciences Law and Policy Center at Berkeley. Several years ago, I found out I was going to come to Harvard, and I was really nervous that everyone would think I was a dummy. And so I rented the book that came from this conference 10 years ago, the book on FDA law, and it was really good. It was like super informative. And the chapters I liked the most in it were ones that I think like survived the test of time, that discussed kind of important things but gave good takeaways. So my chapters kind of really focus on that. And another thing is, just kind of personally, I grew up in the small conservative farm town in the Central Coast of California. And then I the rest of my life lived in Berkeley and New York, not very conservative places. And one thing I've learned is that I think a lot of times we focus on our differences a lot in this space, and we forget that there can be a lot of commonality. So those are kind of the two big drivers of this paper. People have talked about this a lot, but in case anyone is at home and is just joining, including Dad, hi Dad, Dobbs, kind of unsettled Roe. Then we had Alabama's LePage decision, which kind of forced clinics to pause a lot of their force a lot of IVF clinics to pause. Turns out a lot of states, even states that are traditionally not big fans of abortion, are often big fans of IVF. So then Alabama had to kind of do a really quick stopgap with SB 159. So that's kind of this hectic phase. And I think the thing that really sticks with me here is it would be really, really frustrating to be someone who is receiving reproductive assistance during that pause. There are people involved in this, and uncertainty has a real human element here. And I don't like uncertainty in this space. That uncertainty, in my opinion, is just a waste. If you're going to pick one side or another, I'm not really taking a big stance on that, but I just really dislike inefficient and uncertain situations here. So that being said, I think I am the number one perpetrator of this. Sometimes there is a zero-sum trap in this space. We see this in a lot of the post-Dobbs discussions of IVF, where it's like, we need to protect embryos, or we need to give reproductive access, and we need to support biomedical progress. And sometimes those are treated as in opposition to each other. And in some sense, sometimes they are, but I think we can often treat those two as binaries. I say this as someone who does this a lot. And this has been happening for a long time. When I was researching for this paper, I was reading Glenn's really good paper on Shirley v. Sebelius, and we have this quote here. There's, run the risk of curbing progress. You see this in every paper that discusses this trade-off. People go, oh no, we can't do this because it's going to run the risk of curbing progress. And my argument in this paper, and the one I really want the readers of this ultimate book to leave with, is it's more nuanced than that. And there are good ways to design this where we don't necessarily have to have this explicit X versus Y situation. So some fun stories here to kind of illustrate my example. One of my favorite ones to talk about here is in the 1970s, there was a young filmmaker who really wanted to make a Flash Gordon movie. And because of the way US copyright law is written in the United States, he was not able to just make that. He needed to procure a license. And the folks that owned Flash Gordon didn't give him that license. And again, because of the way US copyright law is written in the United States, and I think it's actually pretty good law, you can take inspiration from things, and you can take different motifs or scenes of fare from copyrighted materials and make your own thing. And kind of the classic example there is that that's a real example, and that created Star Wars. We got Star Wars out of that. And there's a lot of great literature about this, about constraints that end up being innovation promoting. Some of the times those can be proscriptive, things that kind of forbid things. A good example of that is the Clean Air Act. When the Clean Air Act was launched, everyone was like, no, it's going to be terrible for the auto industry, and this is going to be really cumbersome, and it's going to be super, super expensive. But in reality, what it did is we pretty quickly developed the catalytic converter, and without that act, probably it would not have been adopted as widely as it was, but the act was put in place. That really incentivized the creation of things that could reduce emissions, and we got the catalytic converter, which is on every car now. Sometimes these laws can also be prescriptive, where they support things. A really good example of that is the orphan drug bill. For those of you not familiar with it, we have a lot of drugs that we know are helpful for patient populations. But the patient population is so small that it's not worth it for a drug manufacturer to set up all the machines to make that drug. And that was a big problem in the United States for a while until Reagan signed the orphan drug bill. And this is definitely not a perfect law, but it actually has done a pretty good job at incentivizing a lot of drug makers who otherwise would not make these drugs to make those drugs. So we kind of steer in one direction or another with a lot of our regulations. I want you, kind of the visual I want you to have, which is just in Amsterdam. So I was looking at all the channels a lot. I want you to imagine when we are discussing things in this space is innovation kind of moves like water. It's like flowing water. When there's motivation, innovation is going to kind of move forward. And when there's no restrictions, it'll kind of move every which way. And sometimes you set up a restriction. It can be a law or a regulation. And sometimes that's a complete blocker. And it'll be like a dam. And it'll really kind of totally block everything. And if sometimes it'll kind of stop a lot of innovation, or sometimes innovation will get so pent up that the dam breaks. But sometimes a regulation doesn't act like a dam. Sometimes it acts like just a little barrier in a channel, and it'll move the water this way, and then sometimes down the line you'll have another little barrier, and it'll move the water in another way. And what we get is not necessarily blockers, but we get channels that move things. So I, in this chapter, discuss this in the stem cell, kind of the history of stem cells, where at every step of the way when one of these things was implemented, people kind of decried them, and they said, this is going to slow innovation, this is going to be not necessarily good for access to a lot of these biomedical innovations. That includes the Dickey-Wicker amendments, which discuss fundings for stem cell research. Section 33A of the America Invents Act, which discusses patentability of different technologies, and it largely barred patents on embryos or human organisms. And then we also got the NIH guidelines, which kind of further elucidated what the government would or would not support. And what came of that was largely a channel, an innovation channel that said if you want to develop stem cells in the United States, you're going to have to fit into all these different channels. That is, if you wanted to use stem cells that were derived from embryos. And this did not totally block things. It is definitely possible to use embryos, and there's been a lot of really interesting histories kind of developing the nuances there. And sometimes it was really confusing, and it really took a lot of years and a lot of court cases to discuss all of this. But it did kind of create a channel. But it also created an environment for those that didn't want to deal with all of these to kind of look for an alternative. And that alternative did arise with iPSCs. And I really like kind of discussing this because Yamanaka, one of the people who won the Nobel Prize for this discovery, and for those that don't know, iPSCs are stem cells that are derived from human cells, so they do not, or human somatic cells, so they don't involve the destruction of an embryo. He intentionally wanted to study this because he had ethical concerns. He had looked at embryos under a microscope and said they reminded him of his daughter, and he didn't want to kind of wade into that world. Now, he didn't do this. He did this in Japan. The United States had nothing to do with his invention. His own ethics drove that. But when those arose, at the time, they were actually not, they were not great technologies. Human embryonic HESCs were way better, and there's a lot of literature, and I've kind of gone back where people are like, iPSCs aren't going to be good. But they bypassed a lot of these issues in the United States, and that created this kind of regulatory environment that was very receptive to that. So I'll kind of end with, I think there's some important design principles from that story. Number one, in the iPSC space, really precise language was clear. What became really important. And sometimes when the language was imprecise, it kind of created unnecessary frictions. The other was we realized that there were spaces that we definitely wanted to protect, and safe harbors were really important. And despite all of these disagreements, there were a lot of things that we cared about protecting. And so I think that safe harbors are another great takeaway from here in the current era. And then finally is, someone has to pay for a lot of things. And so it's really important for us to think about funding and patent advantages for the things that we want to support. I don't think that the people in this room all agree about everything, but I do think in general we probably agree about some things. And if we want it, instead of kind of totally blocking channels by focusing only on those disagreements, if we focus on those points of agreements, we might be able to create, maybe they're circuitous, maybe they're a bit cumbersome, but channels that can kind of promote the types of ethical innovation that we want. All right, thank you.
So my paper discusses some of the ethical and legal quandaries raised by the existence of cryopreserved embryos, and proposes controversially that embryo adoption should be legally promoted and facilitated as a response to the problem of what to do with frozen embryos whose parents have abandoned them. Now, the first half of the paper discusses the current status of frozen IVF embryos under statutory and case law, but since this has been dealt with already in other papers, I largely skip this in the interests of time. But the key points are that the status of frozen embryos is unclear in most states, and that the landmark Tennessee case, Davis v. Davis, discussed earlier, serves as a helpful synthesis of the various approaches state courts have taken in such cases, and also raises some constitutional issues that need to be addressed in defending my central proposal. So my proposal is that states should enact legislation making abandoned embryos legally available for adoption. Embryos would be deemed abandoned if the following conditions are met. Number one, they have been cryopreserved for over 5 years. 2, in the past 5 years, the parents have not attempted or are not in the process of attempting to transfer any of the embryos in the set to the mother's uterus. And 3, after diligent attempts to contact the parents, to notify them that their embryos will be deemed abandoned and made available for adoption, the parents are unable to be located, do not respond within 90 days of receiving notice, or do not attest in their response that they are still planning at some point to use the embryos to attempt a pregnancy. Now, to justify and defend this proposal, obviously a number of legal issues need to be addressed. These include the existence and weight of the state's interest in embryonic human life, the constitutional right to privacy, in particular the right to procreational autonomy articulated in Griswold and Eisenstadt, and the constitutional right of parents to control the custody, care, and education of their children, first articulated in Meyer and Pierce. So in the remainder of the presentation, I'll address each of these issues in turn. So first, the state interest in embryonic human life. Although the existence of a state interest in preserving human life in general is non-controversial, there is significant controversy over whether and to what extent that interest extends to human life at the embryonic stage. State statutes are inconsistent on this matter, and courts have likewise adopted the full spectrum of possible positions, with some treating embryos as property, some as the equivalent to postnatal children, and others assigning them a nebulous intermediate status. The US Supreme Court has not weighed in directly on this question, but it has spoken generally about the state interest in preserving prenatal human life in the context of abortion. Even Roe v. Wade acknowledged that the state has, quote, an important interest in protecting potential life. Roe judged that that state interest in potential human life becomes compelling enough to override a woman's right to bodily privacy only at the point of viability outside the womb. Yet in the case of in vitro embryos, there is no competing right to bodily privacy that overrides the state's interest in potential life even under the Roe framework. And so it could therefore be argued that even under Roe, the state has a sufficient interest in potential life to require that abandoned in vitro embryos be made available for adoption by a woman or couple willing to gestate and raise them. Now, Dobbs further strengthens the claim that the state has an important, perhaps even compelling interest in protecting human life at its earliest stages. Dobbs argues that Roe and Casey were mistaken in their judgments because, quote, what sharply distinguishes the abortion right from the right recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. They are therefore inapposite, unquote. The Dobbs court goes on to argue, criticizing the arbitrariness of Roe's viability line, quote, if, as Roe held, a state's interest in protecting prenatal life is compelling after viability, why isn't that interest equally compelling before viability, unquote. And in outlining possible legitimate reasons for state regulation of abortion, Dobbs asserts, quote, these legitimate interests include respect for and preservation of prenatal life at all stages of development, unquote. If, therefore, the state interest in prenatal life, even at its earliest stages, is strong enough to justify the regulation of abortion at all stages of pregnancy, it is surely strong enough to justify legislation to allow abandoned embryos to be adopted by someone willing to try to gestate them. But what about the right to procreational autonomy under the constitutional right to privacy as articulated in Griswold and then Eisenstadt? The Tennessee Supreme Court draws on these cases in Davis v. Davis, claiming that the state's interest in potential human life is insufficient to justify an infringement on the gamete provider's procreational autonomy. To support this conclusion, the Tennessee Supreme Court emphasized the weight of the constitutional interest in, quote, avoiding genetic parenthood, noting, quote, the technological fact that someone unknown to these parties could gestate these pre-embryos does not alter the fact that these parties, the gamete providers, would become parents in that event, at least in the genetic sense. The profound impact this would have on them supports their right to sole decisional authority as to whether the process of attempting to gestate these pre-embryos should continue, unquote. However, closer examination of Griswold and Eisenstadt indicates that the Tennessee Supreme Court erred in its analysis. The specific privacy right asserted in these cases was the right to use or distribute contraceptives free from government interference, and so to engage in sexual relations while taking measures to avoid procreation. In other words, the right to procreational autonomy in these cases is the right to avoid procreation by preventing the conception of a new human organism. But in the case of cryopreserved embryos, conception clearly has already occurred. A new human distinct from either parent already exists. The question then becomes whether the right to procreational autonomy includes the right to ensure that one's embryonic children will not be given the care and environment that they need to develop to maturity, even if someone else is willing or even greatly desires to provide those things. Under Roe, one might be able to argue for such an extension of procreational autonomy, yet even that I think would be tenuous. For Roe argued that in the early stages of pregnancy, it's the pregnant woman's right to bodily autonomy that outweighs the state's interest in protecting potential life. But the bodily privacy of neither parent is involved in questions about the disposition of cryopreserved embryos. Under Dobbs, the irrelevance of the right of procreational autonomy becomes even stronger. As the Dobbs court notes, the quote, decisions cited by Roe and Casey, including Griswold and Eisenstadt, are inapposite because none of these precedents involves the life of an unborn human being. The same distinction applies when thinking about the constitutionality of a law aimed at protecting the lives of abandoned embryos by making them available for adoption. For the alternative to allowing these embryos to be adopted by others is to consign them to indefinite cryopreservation and eventual destruction. The right to procreational autonomy is therefore not, in my view, an impediment to a law making abandoned embryos available for adoption, for that right only applies prior to the conception of a new human life. Now, what about parental rights under Meyer and Pierce? These rights indicate that parents have the right to control the custody, care, and education of their children, yet as we all know, parental rights are not absolute. They're contingent upon at least a minimal willingness and capacity to fulfill one's basic parental responsibilities. As the Supreme Court held in Santosky v. Kramer, the state may terminate parental rights if there is at least clear and convincing evidence that the parent cannot or will not provide a normal family home for a child. And a cryopreservation tank is certainly not a normal family home. It is therefore, I think, justifiable for the state to terminate the parental rights of those who, over an extended period of time, demonstrate no willingness or plan to provide their frozen embryos with the chance to continue their development. So to conclude, the state has an important interest in the protection of human life, including prenatal life at all stages of development. The existence of millions of cryopreserved embryos, a significant portion of which have been abandoned and will likely die or remain frozen indefinitely in the absence of state intervention, should therefore be of great concern to legislators. I've proposed that one way to address this issue is to pass legislation making abandoned embryos legally available for adoption. I recognize that such legislation would be controversial, but I've argued that it would be justified by the state's interest in protecting human life and would not run afoul of the constitutional right of procreational autonomy or the right of parents to control the custody, care, and education of their children. Further, if such legislation is passed, it would not only give thousands of embryos a chance to grow to maturity, but also enable many infertile couples to fulfill their dream of having a family. Thank you.
Thank you. I think we have time for a few questions, so please indicate. Thanks, Laura. I think we have Glenn. Thanks, Dove. Singbing. Why don't we start with Dove, just in terms of geography?
Thank you. My question is for Susan. I'm wondering about that recent cluster of lower court decisions that enforce procreative use over discard in Maryland, New York, and Pennsylvania. This departs kind of radically from the previous pattern that you had spelled out. And I'm wondering if you read these cases as a stable trend in the other direction, as an artifact of our post-Dobbs moment, or an kind of anomalous decisions that are vulnerable to appellate reversal.
I'm going to defer to Francesca. We had that very discussion, but I'll just make a point that we are in Maryland, Pennsylvania, and New York, not particularly conservative states.
Yeah, so I think when we were researching and writing this, in reading those decisions, we didn't feel that there was enough evidence to really suggest that this was a trend, as much as it was a cluster of courts independently reviewing the agreements that were in front of them and coming to the agreement that it was not against public policy in any way to find that they were binding agreements and demonstrate a willingness to enforce them. So I believe one in New York is currently on appeal, so it'll be interesting to see how that comes down, but I don't think we felt that there was enough evidence to really suggest that it was a trend, as much as just to identify that these cases were departing from the pattern that we'd identified previously.
And just to be clear, I don't think any of them suggested a post-Dobbs impact, if you will. In fact, there are two state courts that ducked cases recently in Texas, and I'm blanking on the other, which I was expecting to see them take that invitation. So I do not take this as a post-Dobbs indicator. And as Francesca said, I don't know what else we make of it other than to keep watching.
Could I add a comment to that? Sorry, I know this is taking time, but thanks, Deb, for that question. There's another case recently decided in Ohio, and I watched that because it's across the river from where we live. And likewise, it does give the embryo to the woman against the man's wishes. And what they adopt is what looks like it's going to be a bit of a safe harbor. They call it absolute parental disentanglement. And Susan mentioned this, where the decree warrants that the man cannot be told about any use, any result of the use, that he is absolutely absolved of any responsibility, and again, disaggregating genetic and legal parentage. And that might be the trend that we should be watching, not necessarily the decision itself, but the ancillary aspects of the decision. And I think I see that in our future. Thanks for the opportunity. Sing Ping.
Thank you all. I have a question for our panelists here. I want to understand how likely your potential legislations can gain enough legislative momentum. For example, for Susan and Francesca, I want to understand, is the organization actively lobbying for this kind of model law? And for Vincent, I had a very similar expectation that about a safe harbor, but from my legislative mapping, I saw many states resist the idea, giving safe harbor even after LePage. So I was wondering how likely that this kind of law can get passed. And for Melissa, I even see a bill about adoption, embryo adoption in Massachusetts. So I was wondering how likely this kind of law can get passed in no matter which state in the United States. Thank you all.
Sure, I can start. I mean, I don't really know that much about the political feasibility of the law, although one thing that I do think is interesting is that I think if explained and publicly promoted in the right ways, I think that these laws may be able to garner a fairly broad kind of coalition of support because there are many people who would really welcome the ability to adopt some of these frozen embryos as an alternative, perhaps, to doing IVF themselves, maybe because they don't want to go through the process of IVF, or they have ethical issues with IVF, but would be happy to adopt frozen embryos, as the case of many Christians who have some ethical concerns with the way IVF is done. So I think you might kind of get a broad coalition in terms of a kind of opening up procreative options. In ways that don't foreclose the possibility of others who want to continue to do IVF to do it. So I think with the appropriate safeguards, things like ensuring that the genetic parents have no responsibilities, right, that have been talked about, I think you might end up with potentially broad support for this.
Yes, please, go ahead, Susan.
Two things. One is the argument you made concerned me in one other way, which is that I didn't see why it stopped at abandoned embryos or unused embryos, because if parents patients disclaim their use of embryos, they don't want them anymore, it seems those arguments would also allow for those embryos to be made available. And one practical point, because as I said, I do a lot of practice, I know IVF doctors who are very, very concerned because they have patients coming to them saying, I don't want to do IVF myself because there are these embryos that need a home. And so please let me use these excess embryos. It is my duty to do this. And they are getting cycle after cycle where they're not getting pregnant because they are using donated embryos that are not of the quality that they would if they used their own IVF. And I've had doctors just say to me, this isn't what I went into practice to do. I went into practice to help people build families, not to be in this situation. So I think there's a lot of nuance to this question that we need to sort of make sure we identify. We can disagree, but I think we need a lot of facts on the table.
Just to respond to the point, I also am kind of surprised that there's not as much a safe harbor for IVF. And I think largely, that is what we should build in. It seems like it's a very popular thing, and we should figure out some common denominator, and maybe that common denominator changed by state. But it does seem like pretty much every state would support something like that. I will note, for the people that weren't listening last night, I was looking into it, the CEDAR Act from the folks at Bloom, fantastic, and I think that's a great model for a lot of states to adopt. And frankly, they're not adopting it yet because probably there hasn't been enough political will or enough frictions yet. But when those things pop up, it's like really unfortunate because that is real families like on pretty tight timelines, and I think proactive legislation would be a great move here.
Okay, just to, well, Glenn, and I think we have Leslie and Katie.
Great. So I have a comment from Melissa. I think your argument is easier and harder than you make it sound. I'll start with the good news. The easier is that, like, if you read all the embryo disposition disputes, almost none of them, I don't think any of them actually rely on the federal constitution. Occasionally there's like a snippet here, and indeed, this makes me feel old. My job talk in 2008, I argued the Constitution has nothing to say about that. So that's the easy part, and I think that's an easier claim to make. The harder part is I think there's some slippage between an argument about interest against destruction versus interest against continued cryopreservation. And I think we need to have an argument about what the moral status of being a cryopreserved embryo is as opposed to an embryo that's being destroyed, and then the constitutional interest in preventing continued cryopreservation as opposed to preventing destruction. Because you might think one possible solution is just continued cryopreservation indefinitely, although we know that at some point that will result in non-viability.
Yeah, thank you. I mean, just to answer briefly, I mean, I think my main response to your question is what you said at the end, which is in a case where the embryos are going to be cryopreserved indefinitely because the genetic parents are unable, unwilling, have no plan at all at any time in the future to make use of them, that's effectively a recipe for destruction. Sooner or later, right? And so if there is an interest against destruction, I think then there is an indirect interest in limiting the amount of time that embryos can be cryopreserved if parents indicate no willingness or plan to use the embryos themselves.
Leslie.
Thank you to all of the panelists for these terrific papers. In this question, really want to focus on Melissa's comments and put it into conversation with Lisa and Yaniv's paper. And my question is really about how to square the view that individuals who use gametes from others for reproductive purposes generally desire, we might even say should have access to some medically relevant information about the sources of those gametes. In the context of adoption of abandoned embryos, we also bump up against the problem that Susan identified, which is that these embryos may be of lesser quality. So I'm wondering, Melissa, what your perspective is on whether the individual or individuals adopting embryos ought to have access to the medical history of the individuals whose gametes formed those embryos, and if so, how you square that with existing HIPAA and other privacy rules.
Yeah, that's an interesting question. I mean, I think there are two ways to do this. I think one way is to say that the individuals should have access to the information, but that it would be anonymous, so you wouldn't know whose history you were getting. You wouldn't have any names, but you would know that the gametes, are from parent A and parent B, and parent A's medical history includes XYZ, and parent B's medical history includes XYZ, right? So that you'd have at least some information of that sort. Another route to go, if that becomes too problematic in terms of privacy, is simply to say, as is the case in many instances of infant adoption, that this information is largely unavailable. Or at least partially unavailable. If you're, doing an infant adoption where the father is unknown, for instance, or where the mother wants to provide no information, parents go into that simply saying, okay, well, we'll accept this child, or we'll see how the child looks after birth, or we're willing to accept the child with whatever anomalies the child may have medically, or whatever difficulties, or similar also to adoption of foster children, where there are likely to be a number of issues due to the traumatic circumstances that they have been raised in many instances, and the adoptive parents simply need to be made aware that this is a risk that they take. But as we see again in many cases of postnatal adoption, many parents really are quite happy to take those risks. and in some instances even feel called to help children in those more disadvantaged circumstances.
And Katie, we'll give you the last.
Great, thank you. So Susan and Francesca, I hear your argument, and I actually think that part of what you're arguing for maps on to what you're seeing in the cluster of cases that you talk about, which I would say is the disaggregation or the acceptance that the law would disaggregate genetic connection and parentage, right? That's what the court did, and that's one of the sort of bullet points that you say in your recommendations that you can do that. So I actually think your argument is stronger and that the courts are like secretly listening to you.
Yeah. It's also endorsed by the UPA.
Yeah.
So we've got some real model legislation. Go ahead.
No notes. Melissa, I had a question for you about if you have any like sort of distributive justice concerns. It sort of tags onto Leslie's question. So I think when I think of the embryos that are left over, those beautiful blastocysts, right, that I talked about, those beautiful blastocysts are probably going to be used by the patients. And what's left over and sometimes abandoned often, right, are the lower quality embryos. Leslie sort of touched on this. So in the scenario that you talk about, preparing uterus for implantation way cheaper than going through IVF. So do you have any concerns about how your model could lead to this sort of gentrification of IVF, that people with fewer resources would be accessing embryos that were less likely to result in a live birth? Have you thought about any of those issues?
Yeah, I think that's an interesting question. I mean, I think that those who are considering embryo adoption should be made fully aware, that this is the situation, that the way IVF currently works, the embryos that are, graded the highest or, have tested as, without any genetic anomalies, that those are the ones that are used first and so have the highest likelihood of success. And then as you go on down the line, of course, likelihood of success goes down. Now, that doesn't mean that, you can't have a perfectly healthy baby through embryo adoption. I'm currently pregnant actually with an adopted embryo and have a number of friends who have adopted embryos and wonderful, perfectly healthy children. But I also have experienced a number of failed embryo transfers and a miscarriage through the embryo adoption process. Now I'm very well informed about all of this, so I go into it with complete knowledge that yes, well, we're getting the embryos that are less likely to succeed. And so, I knew about that, but I think the informed consent thing should be emphasized, that the parents, prospective parents considering this should be made aware that their chances of success are, for a successful embryo transfer, are probably on average lower than if they had done IVF. Now, of course, if you're an older parent, and don't want to use an egg donor, for instance, well, of course, your chances of success are probably much higher with embryo adoption. So it will depend on the circumstances. But I think full information is essential. But with that, I think many people would still choose this option, and that it's, as you say, a lot less costly and a lot less taxing on the woman's body than the requirements for a full round of IVF.
Thanks, everyone, so much.
Thank you.